Our next speaker, I'm so glad that we have an opportunity to have him for our presentation. Kirk Nara is a partner with Wiley Rain here in Washington, D.C., where he specializes in privacy and information security counseling and litigation. He is chair of the firm's privacy practice and co-chair of its healthcare practice. He served on the board of directors of the International Association of Privacy Professionals, or IAPP, where he is a frequent speaker and quite a visionary in the convergence of privacy and security. He's been on the board of IAPP for more than a decade and is an editor of the Privacy Advisor, the monthly IAPP newsletter. If you're not a member of IAPP, I encourage you to join. He is a graduate of Georgetown University and the Harvard School of Law. So I welcome Kirk. Thank you for coming today.
Good morning, everybody. Thank you for having me today. I'm always a little nervous following Leon. I know that you're all scared to death, and I don't know whether you need some time to digest that before I dive right in. Maybe that makes me look good by comparison, because I will not try to scare you. I'm always a little surprised listening to him. I have this sense of, if any of you remember the Far Side cartoons, he's very soothing, and his message is clearly that they are not out to get people and they are not going to be overly aggressive in their enforcement. But I know that what people hear is blah, 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 high penalties, blah, 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 enforcement. So never quite sure what to do about that. My session today is going to be a little different from a lot of what you're going to see. Obviously, we're talking a lot about the new rules, and you're talking a lot about security practices. You know, new rules are out. There's a lot to digest there. We don't even have to have compliance for those rules yet. However, I'm going to start talking about what's next on healthcare privacy and security. It's interesting when you think about the time frames of what we're talking about. We are talking largely about a privacy rule that was written. Most of it was written in 1999 and 2000. We have a security rule that comes out in 2003. We then have high-tech law in 2009 with the changes just getting implemented. But that means essentially there's been one modest set of changes to those rules since 2003. And obviously nothing's happened in the healthcare industry in that decade. There's been no changes of any kind across the healthcare industry. So what I'm going to focus on is to look sort of what's ahead, what's coming up next, both in terms of some of the specific HIPAA issues as well as some of the other issues that are happening in the healthcare space. A lot of what I'm going to talk about, particularly in the second half of my presentation, gets to one of the questions that was asked, which talked about the mental health and substance abuse rules. I'm going to be talking about some developments related to what HIPAA applies to and healthcare information in general, because again, if you think about what HIPAA does and doesn't do, nobody would write a set of privacy rules the way that HIPAA has existed at this point, because it didn't come out as a privacy rule. It came out because of standard transactions and administrative simplification, and we ended up in a variety of places now through history. But if you were starting to write a healthcare privacy rule, you just simply wouldn't have written a rule this way. So we're going to talk a little bit about how some things are happening in that regard. So let me start off with a couple of, I would say, tips maybe in terms of compliance. We obviously are still digesting these rules. There's a lot there. I do think it is important to recognize that despite how much change there is in the high-tech rules, the changes don't affect about 80% of what's in HIPAA. So it affects a small number of provisions, perhaps in significant ways, but most of what we've gotten used to doing over the last decade or so has not really changed. That's important to recognize. So a couple of things that I'm paying the most attention to over the next few months. One is how to deal with the new breach regulation. And in particular, what I want people to do is over the next 6 months, I guess a little fewer than that now, when you have breach situations, and as the director indicated, you will have those situations, what I want you to do is I want you to evaluate your breaches or your incidents against both standards. And I want you to see what's going to happen differently. My view, which the director didn't say today, but he said in other situations in the past, is that in most situations the answer is going to be the same. And if the answers are different, I want you to really focus on what it is that makes them different. My view is that ultimately you're not going to see very many differences. But let's play that out. Let's use this time to figure that out. It may just simply give you some comfort that it's not really much different than what you've been dealing with for the last couple of years. Develop a plan for your contracts with business associates, whether you are a business associate or you're a covered entity. We could debate, and I didn't throw this into my slides later, although I could have, whether there's even any need for business associate contracts. There's a lot of it is just a waste of time now because business associates have to follow the rules themselves. But most entities are going to have to change their contracts. It's an opportunity to do things differently. You don't have to do things dramatically differently, but you need a plan for that because that's something that takes a while. For business associates, the major focus is on the HIPAA security rule. I have been surprised at how many people I deal with who are business associates who are scared about their need to comply with the privacy rule. And I say, well, what exactly have you been doing for the past 10 years when the contract said you had to do all the exact same things? Oh, yeah, okay, it takes them a minute to figure that out. So be aware of that, but the security rule is clearly different because you're moving as a business associate from reasonable and appropriate to compliance with the full HIPAA security rule. Now, as the director indicated, that's still very much a flexible, scalable, reasonable approach, but it's a much more detailed approach, and it covers a lot of particulars that business associates have not necessarily been familiar with. And then last, think about the sale and marketing issues that come up here. I will tell you that this is having more of an effect than I sort of thought it would because when the high-tech law came out and said you can't sell PHI anymore, my view was, well, wait a minute, how were we allowed to do that before? But it turns out there are lots of situations that implicate those provisions, particularly with the way that the exceptions have been defined. So pay attention to that point, pay attention to the marketing issues. And those, I think, are really some of the major ones to be paying attention to. What's next on the regulatory front? The director alluded to the HIPAA accounting rule. I was asked not to give my full and complete opinion on the HIPAA accounting proposal, so I will not do that. You may be able to read into it a little bit what I thought of the proposed rule. This is a holdover from the high-tech law. It is indicative of one of the themes that I'm going to go over today, which is a disconnect between what we're trying to accomplish. Congress said in the high-tech law, we really, really want healthcare providers to implement electronic health records. If you do, we're going to impose harder compliance standards on you. So think about that, and that's sort of what happened here. So there is a separate notice of proposed rulemaking on the accounting rule. What Congress did is it said, let's pick the part of HIPAA that nobody cares about, is the least important part of the HIPAA rule because patients aren't using it, and let's make it really hard to comply with. So what we have is a separate timetable, a separate NPRM. Some of us hope that that is delayed indefinitely until I'm retired, but we'll see if that's going to work. Remember what the statute said. If you utilize an electronic health record, you will no longer have an exception for TPO, treatment payment healthcare operations, for disclosures through that electronic health record. Now, most people read that and they said, we saw the disconnect. And what we thought there was going to be was a rule that would be very limited to disclosures that were made through an electronic health record, and the electronic health record we'd be talking about would be the ones that were given meaningful use incentive payments. I get that. That's not at all what the proposed regulation said. It was a much broader regulation that created some really fundamental changes to the HIPAA accounting rule. So we're going to be looking at that. Lots of comments were, in fact, submitted. I think it's fair to say that it was somewhat unusual in the sense that virtually no one supported the proposed rule in its entirety. Usually you have sort of some people think it's great, some people think it's not, in all directions. Most people were against the rule to some extent and to a large extent. There are a couple of implications for now. First of all, I would tell nobody in this room to go out and build an access report as described in the HIPAA accounting rule. I hope that won't come. It may come, but if it does, it's a long way off, and I certainly wouldn't do anything with that today. What you do need to do is pay close attention in the proposed rule to the discussion of audit trails, because part of the premise of the proposal is that the security rule requires a lot of specific detail about audit trails, which most of us did not think it, in fact, covers. So be aware of that. You have to have a plan for dealing with the audit rule. So be conscious of that. In the big picture, I think the real question that we're going to look at as a policy matter is this proposed rulemaking reflecting a significant change in approach, and we're now turning the accounting rule into really a central point of the privacy rule, Or is it something else? I don't know the answer to that. I'm sort of hoping it's something else. Will this accounting rule become a major financial and compliance challenge? If the proposed rule was passed as written, it would be an enormous burden on everybody in this room. Now again, that's not by itself to say it's not appropriate, but it's an enormous challenge for everybody. Hard to see how it's consistent with some of the regulatory streamlining approaches that are out there, and it seems to dramatically tilt the balance between patient interest and compliance burden. So we will be watching that going forward to see if this is something more significant. A couple of other issues on the regulatory front that are coming out. Minimum necessary guidance is promised at some point. I think it's really hard to do minimum necessary guidance. I don't know how you tell a hospital, here's how you have to act in a certain way when you are doing your business as a hospital. Because not all hospitals are the same, and I don't know how that guidance is going to translate to a doctor or a pharmacy or a health insurer or anyone else. So I think it's actually very hard to do that. I think what we are likely to see is guidance on process more than substance. Again, following through on what the director said a few minutes ago, nobody is going to have an enforcement penalty brought against them because they made a misjudgment as to whether a data element should be included in minimum necessary or not. You should think it through, and you should always be conscious of what's the minimum necessary, but that's not by itself going to create enforcement concerns. I should tell people, by the way, the two cases that the government has brought over the past decade that have scared people I deal with more than anyone else, two cases. One was the first HIPAA criminal case, where a lovely individual who worked for a hospice out in Washington State stole information from dying cancer patients and used it to set up fake credit cards. People were worried to death about that case. I'm like, tell you people not to steal information and commit fraud. All right, end of the day. I don't view that as a training problem, that the guy thought it was okay to do that. It wasn't an interpretation issue of HIPAA. The other one is the Signet case that the director alluded to. The message from that case, don't ignore 57 letters from HHS, particularly when they're delivered by federal marshals. Don't do that either. All right, that's my enforcement advice for the day. Is there anything else that should be done with the HIPAA rules? One of the most interesting sentences in the proposed rule from July of 2010 was that OCR said they were not going to be limited in their proposals to what was in high tech. They were, in fact, going to look back over their decade of experience in enforcing these rules to come out with changes to the privacy and security rules themselves. And unless you are really focused on the importance of the records of people who have been dead for more than 50 years, they didn't really do much with that after the fact. They changed the rules on the 50-year-old dead people records. But think about that. I mean, these rules have been in place for a long time now. It was a major effort to write those rules in the first place because Congress, unlike in high tech where they wrote the words in a lot of situations, what the HIPAA law says about privacy is there shall be privacy rules. So HHS was starting with a blank slate on that. They got a lot of things right. I mean, I think it's a great rule in a lot of respects. But are there fixes that should be made? Are there things that we should be doing differently? I would love to see some more analysis on that. We really didn't get that in the high-tech final rule. Again, that wasn't an obligation. I thought when they said they were going to do that we would see more of it. But let's pay attention to that, and I think it's probably a good time to start that discussion. Another area where there will be some regulatory guidance will be on de-identification. There's been a little bit of guidance so far, particularly on the technical front. Will there be more coming? I think that the emphasis that we're seeing on big data that goes along with both the existence of that data, the technology for re-identification, some of the money that's involved in this field, I think we're going to see a lot of attention on that issue, so I would expect some more on de-identification and big data in the healthcare industry. Security practices. It is important to keep in mind the omnibus regulation did not make any changes to the HIPAA security rule other than who it applies to. So it applies to business associates now. We've all known that since the high-tech law was passed. But there were no tweaks to the HIPAA security rule. That means that we have a rule that was, written in, 2002 or so, 2003, went into effect in 2005. Obviously, security is very different today. Security practices are different today. I think you could look at the security rule and say that because it is so process-focused that it actually still fits the environment today. And I think there's a lot of that's a very important piece to understand. But you need to be changing your security practices to keep pace with these technological practices. You could have put in privacy rule provisions on your access reports or amendments or things like that in 2003, and that would still work today. If you're working with your 2005 security program, you're clearly in violation of the rule today. So I do think we will expect to see much more pressure to generally improve security practices. I think we will see real pressure to encrypt more data. It's cheaper than it was. It's easier to work with. It's not a perfect standard, as one of the questions indicated a few minutes ago. And I do think both enforcement actions and, perhaps more importantly, all the publicity that goes with security breach notices will in fact lead to people encrypting more. So you always want to look at whether you can encrypt. It's always a good thing to be thinking about. My last bullet up there about watching Congress, I'm going to come back to that in a minute, but that's going to be a real thing to watch on security practices for everyone. All right, let me move into some of the policy areas that are being talked about. Mobile devices. I know you heard a little bit about mobile devices yesterday. I just view mobile devices as sort of a microcosm of some of the dilemmas we are seeing in the healthcare policy area. First of all, it's just it's an area that nobody even thought about when these rules were being written in the first place. They didn't exist. It wasn't an option. There was no, an app was something you filled out when you wanted to get a job. So all kinds of developments. Healthcare is obviously not the only element of that, but it's an important piece for this. The Federal Trade Commission is reviewing applications, wireless devices, things like that. They've called the application area the Wild West, the unregulated Wild West. So be looking at what's going to happen there. The FTC's action clearly will affect the healthcare industry. It's not directed at the healthcare industry, but keep in mind that they are looking, and this is a key element of HIPAA's scope, they are looking at things in the healthcare industry that are healthcare but not HIPAA. And one of the challenges that this device, the mobile device area, is highlighting is how much there is in healthcare that is not, in fact, part of HIPAA because of the scope of HIPAA. So it highlights the question about scope of HIPAA. It highlights the question about patient engagement in their own healthcare. Ongoing questions about when you can have appropriate patient engagement that's either consistent with the HIPAA standards without the need for HIPAA standards because it's outside of the HIPAA scope, with agreement, for example, the discussion a few minutes ago about emailing with patients. All of these issues are real challenges to try and work out the appropriate step. And I think the questions that we had at the end of the director session highlight some of those issues. It is fine to say, and I think the director's doing everything he can to make this clear, it's okay for people to send emails to patients if they want to get emails from their doctors, but that isn't, it's not a get-out-of-jail-free card in every possible scenario. So you've got to be thinking about that. The mobile device issue is highlighting that for our industry because of how beneficial it can be for so many patients. But as soon as you get into having the patients in control of a lot of that information, a lot of the protections that we think about either are diminished or may disappear entirely. So what does that say about the need for a broader HIPAA? Keep in mind, we still have a HIPAA structure that is defined by covered entities. That means there are lots of businesses who have lots of healthcare information who are not within the scope of that. We've broadened it out a little bit by applying the rules to business associates, but that still means that you need a covered entity at the center of that. So we've got a situation, this is not new, but I think the percentage has gone up, of segments of the healthcare industry who simply aren't part of the HIPAA structure. And I think we're seeing more and more attention being paid to that gap. So how are we going to deal with that? What are some of the efforts that are out there to deal with this? We are seeing various kinds of legislation that are dealing with privacy and security issues that may affect the healthcare industry, but it's not clear how it will affect the healthcare industry. We're seeing some kinds of specialty legislative proposals that deal with particular pieces of information in the healthcare industry. I think that's sort of a minor part of this discussion. Are we going to see any kind of legislation to change anything about HIPAA as a result either of the omnibus regulation or anything else? For example, one of the discussion points was clearly the breach notice rule, and one of the reasons, not the only reason by any stretch, but one of the reasons for the change in the standard in the final breach rule was congressional concern about the significant risk of harm threshold. Now, I haven't heard that concern once the final reg came out, but possibly you could see Congress saying we want to step in and do X, Y, and Z to correct, amend, modify, whatever word you want to use, the omnibus rule. That's a possibility. The two more significant possibilities are related to other legislative developments in Congress. For example, most of you are probably familiar, at least to some extent, with the debate on cybersecurity in Congress. That was very active last year. We had an executive order that came out on cybersecurity. Right now, the way that is playing out, it has a very limited impact on the healthcare industry, and just frankly, in general, there's going to be more pressure on that area. We saw a related development because there were separate pieces of legislation dealing with federal security practices, federal legislation on security practices, and federal legislation on data breach notification. These were essentially bills that would impose security practices on every business entity in the country, independent of the sector you were in. They would be general security practices. There was also a lot of movement to have general legislation on breach notification at the federal level. And the link to cybersecurity is that those information security and breach notification bills were both proceeding through Congress on their own and were possibly being attached to the cybersecurity legislation. So there are a number of vehicles where we may in fact see national legislation on information security or on breach notification. And the issue for the healthcare industry is, will you be included in that? Will you be carved out from that legislation? And the even trickier point of, what do you want the answer to be? Let me give you one clear example, which I think is not getting enough consideration right now. Obviously, the healthcare industry focuses on the breach notification regulation. Got that. There are state laws in 46 or 47 states right now. Most people hate dealing with those laws, and you still have to deal with them even if you have a HIPAA breach. The federal legislation, as it's been written now, would preempt all of those state laws, meaning all you'd have to do is follow the federal law. That's great if you're a retailer. But if you're a healthcare company and you're carved out from the federal legislation, as most of the proposals say, you won't get the benefits of the preemption. So do you want to follow HIPAA plus a federal law, or do you want to follow HIPAA plus 46 state laws? That's the question, and I'm not sure of the answer, but it's not given enough consideration right now. Related point, the Federal Trade Commission has had probably 25 or 30 enforcement cases over the past few years where it has essentially taken steps to impose security obligations on every business. They have basically said that if your business fits either of these criteria, you have customers or employees. Anybody work for a company like that? All right. You have to have reasonable and appropriate safeguards to protect information. They've imposed cases on all kinds of industries where there's no law saying they have to do anything. One of the defendants in that case, Wyndham Hotels, has challenged the FTC's ability to do that. If Wyndham wins that case, I think what that does is it puts a lot more pressure on Congress to go back and pass a law that imposes those security practices. If the FTC can do this, you may say there's no need for federal law. If the FTC can't, we're going to see more pressure on that. A couple of other points. Now, again, moving into some of these related areas in the healthcare industry. Health information exchanges. I underline information because we have two very confusing HIEs we are talking about in the healthcare area right now. Health information exchanges. These are the efforts to build centralized areas for exchange of patient information for treatment, various beneficial patient purposes. That's largely proceeding outside of the HIPAA discussions. There's a separate part of the government, closely coordinated, but a separate part of the government working on that. These exchanges clearly have been bogged down by privacy and security rules. There's other factors as well. The issue in a lot of these is the issue that was highlighted earlier about mental health and things like that. There are all kinds of other laws that are affecting how those exchanges are being built. My personal view, let me be clear, this is my personal view, is that if we build health information exchanges where the goal is to have patient information that is thorough, reliable, we're not going to make mistakes, we're going to know what tests have been done, we're going to have complete, accurate information, that goal will not be achieved if we give individuals a situation where they can pick and choose what information goes into those records. And that will affect not only those individuals who pick and choose, but it will affect everyone else because doctors and hospitals won't know. My view is that the privacy and security rules are going to prevent HIEs from working the way they're currently being structured. That's just that. I think that's a factual statement. That doesn't mean you do it or you don't do it. It means that we should go into this with our eyes open, and we're setting up a situation where the rules are different in the HIEs than they are under HIPAA. Same issue with the health insurance exchanges. Those are also being built where they're half in and they're half out of HIPAA. Some of the entities aren't part of HIPAA, some of them are. The rules right now basically let every state exchange decide on their own privacy and security rules. Again, creating a mess, creating complication. And one of the points that I take away from both the earlier questions and some of the experiences I've had in this industry is the fact that we have all these different rules is itself a problem. That confusion is itself a problem. My view, again, just personal view, give me one rule. I don't even care what it says. Give me one rule that we can follow. I think that would be a much easier situation, but we don't have that right now in the healthcare industry. And what we're seeing is more confusion and more rules being added rather than fewer. Same issues are coming up in the research area. Lots of opportunities for research because of all the data that's being gathered. There were some changes that I think were positive in the HIPAA rules that will help in some instances. But again, lots of opportunities, not sure we're capitalizing on that most effectively. International environment is also complicating things. No matter how much you dislike the complication of privacy and security rules in the United States, the international rules are worse. They are more burdensome, and they impose much more significant compliance challenges for anybody dealing with the international environment. Healthcare is, obviously there's a United States set of rules, but healthcare is global. More and more of your data is global. And the developments internationally are going to create some real challenges for how data flow works in the international environment as well. So keep an eye on that one. The European Union rules in particular are already much tougher than they are in the U.S., and it's likely that those rules will be made even more challenging over the next couple of years. So, conclusions, a lot happening in this area, both in and out of HIPAA. I think everyone's on top of the HIPAA developments, but what I'm seeing is more developments and challenges outside of HIPAA in addition to what we're seeing as compliance challenges with the new rules. So you need to be thinking about this whole package of issues when you're designing compliance activities, thinking about your business, how you're going to run your operations, et cetera. Are we going to see a convergence on these issues, either through a broader HIPAA rule or something else that wraps healthcare into it? Possible. I still don't think it's likely. I think what we're going to see is a couple of additions that will have effects without really straightening things out. If we had one rule, is that good? Is that bad? Who is it? You've got all these questions about who's gains from that situation. I think there's a value to the system from everybody understanding what the rules are. And I think, again, you've seen a lot of discussion, whether it's nervousness about enforcement or other issues, where people just don't know what to do because they are confused by the rules. I never think that's a good result. But what we're seeing in the healthcare industry is a proliferation of rules rather than a centralization at this point. And I think that's just a worrisome trend. So with that, do I have time for questions at all? Or should have time for a couple questions if anybody has any? Otherwise, we will move on. Questions from anyone? Don't have to run, but go ahead.
I don't want to miss my chance. Can you give us your thoughts, just general thoughts and speculation, I know it's speculation, about the Accounting for Disclosures rule and what proposals might come out?
That's a tough one. All right, thanks for setting me up, David. I didn't pay her to do that, so I won't. I'll say a couple things. I think the proposed rule is unworkable. I would throw it out. What I would do, because again, what we have is we have some patient interest, but it's not entirely clear to me what the patient interest is. And I think if you read through the proposed rule, it's hard to figure out what the patient interest is. And so my personal view is that most of the patient interests that have been identified, understanding what happens to data, being able to ask questions in certain situations, being able to file complaints, I think those can be handled better through means that are not accounting of disclosures. Privacy notices, for example, tell patients all the things that are being done with their information. The fact that you're sending information to this business associate rather than that business associate, I'm not sure how much interest there is. So what I would like to see is a much narrower rule that says exactly what the statute says, which is when you make disclosures through an electronic health record, which I would define as these meaningful use records, and I define it that way because that guarantees that the technology exists. That's what I would do, and I would limit it to that. Now, whether it will go that far, I don't know. I think the challenge is to say, look, we're going to make you do something, and we're going to make you build a system that is enormously complicated because of the possibility that some patients might ask about something like that. I think that's a real challenge. I think that's where we are right now. So I think we're going to see a much narrower rule. I just don't know if it'll be narrow enough to be sort of a workable solution. With that, thank you very much for your attention today.